Lawsuits for malicious prosecution under Section 1983, often misunderstood by law enforcement. What are they? What elements does a plaintiff have to prove to be successful? And what does this brand new case out of the United States Supreme Court tell us about malicious prosecutions? Have they made it easier? Well, I'm going to tell you in this episode of the podcast right now. What's up, everybody? Welcome back. This is the Tactical In-Service Podcast, a podcast for law enforcement where I teach law enforcement the law to help them regain their confidence and transform their careers. On today's episode of the podcast, I'm going to be talking about fairly recent United States Supreme Court decision, Thompson versus Clark. Now, I'll tell you from the onset, this isn't great for law enforcement. It does make it easier for a plaintiff to sue under Section 1983 for malicious prosecution, but it may not be as bad as you think. And if you know the law and you have probable cause to arrest someone, then this case really isn't going to make a difference. It just makes it easier for someone to sue. I'm going to explain in this episode of the podcast. Before I dive in, I want to make a couple of really quick announcements. At the time of recording this episode, I have two courses coming up that I think you're going to be interested in if you're a New Mexico officer. Number one, I'm doing my legal update, New Mexico legal update. That's free. That is a virtual training that you can register for in the link that I've left in the description down below. We're going to be doing that on August 4th, and it's going to be from about 8 to 10 o'clock in the morning. It is 2 hours, and it's NMDPS approved for that credit for your biennium. So make sure you get signed up. This is probably the last legal update I'm going to do this year, the last free legal update that I'm going to do this year. Had a huge turnout last time and a lot of requests for it, so get signed up. The second announcement is I'm really happy and excited about this. Going to be doing an in-person training on New Mexico search and seizure at the Las Cruces Police Department on September 19th, I believe. Link in the description below on how you can get signed up. Make sure if you're interested, you get signed up here early because I only got 15 spots. We're very limited on this. 15 spots available. So if you're an officer in that area or your department will let you travel, go to my website, policelegaltraining.com, or just go to the link in the description below. All right, let's dive into Thompson versus Clark. So let's pull it up here on the screen, shall we? And I'll show you what I'm looking at here. By the way, you can pull up every United States Supreme Court case by just going to the Supreme Court's website, and they issue the opinions here. Quick version of the facts. Thompson's at home. Apparently, he's got a sister that suffers from mental illness. She calls the police alleging that he has, I think, abused or sexually abused the newborn baby. That's a pretty serious call if you're in law enforcement. So EMTs come out. Thompson refuses to let people in, basically saying, my sister-in-law is crazy. You're not coming in. Police show up, as you would expect, and they find this to be, a serious situation, so they want to come in. Thompson says no. So now police are entering the house without a warrant. You can see where this is going. Thompson, because he has refused to allow the officers in, is now being charged with, their version of resisting evading a lawful order of a police officer. He gets arrested, spends 2 days in jail. The prosecutor dismisses the case, doesn't give a reason, which is very common. As a prosecutor, I didn't write the reasons. It didn't matter. If I'm filing a dismissal or a nolli prosecco, I'm just writing it's in the best interest of justice. A lot of reasons for doing that, but that's what they did in this case as well. So what do you think Thompson does? Files a lawsuit under Section 1983, which you've heard me talk about on this channel before. This is the federal statute that allows citizens to sue the government. That's you, state and local police officers, for alleged civil rights violations. We see this a lot in the context of the Fourth Amendment. So there was a number of claims in this case under the Fourth Amendment. Specifically, the issue in this case was malicious prosecution as one of the claims. So what is a malicious prosecution? What does a plaintiff have to prove? The court gives you a little bit of that idea here in the synopsis and kind of in the initial thing. They tell you right at the onset here, if you take a look at the screen, to maintain that Fourth Amendment claim under 1983, a plaintiff such as Thompson must demonstrate, among other things, that he obtained a favorable termination of the underlying criminal prosecution. I'm going to go into a little bit more detail on this as we go on throughout the opinion. This is known as a heck bar. This is why if you have a criminal case pending and then a civil lawsuit, the civil suit will usually wait for the criminal case to get done, because if someone's convicted in the criminal case, then that may eliminate some of their claims. You can't claim that it was a malicious prosecution if you were convicted by the jury. That was the issue in this case, was the DA dismissed the case. So what does that mean? Does that mean that it's a favorable outcome and they can proceed in the malicious prosecution claim? Or do they have to show some affirmative findings of innocence? It's pretty easy. If you go to a jury trial and you win and you get acquitted, then that's easier to show than it was just dismissed for no reason by the DA. There's been a split in the circuits here, and this was a case where the Supreme Court was going to answer that question. All right, so the next thing you see in the syllabus is the holding. So let me frame this up a little bit more. The issue, the specific issue in this case, which we're going to pull out here in just a minute, was for a plaintiff to go forward in a malicious prosecution case, there are some elements they have to prove. One of those elements that they have to prove is that the prosecution terminated in an acquittal or discharge of the accused. So they have to show a favorable outcome in the criminal case, or the civil case gets dismissed. It can't survive if that element's not met. That's the issue in this case. The court had to determine, what does that mean to have a favorable outcome? So what does that mean? What do they have to show? There's been a split in the circuits. The court has answered that now. They say, to demonstrate a favorable termination of a criminal prosecution for purposes of the Fourth Amendment claim under 1983 for malicious prosecution, a plaintiff need not show that the criminal prosecution ended with some affirmative indication of innocence. A plaintiff need only show that his prosecution ended without a conviction. Thompson has satisfied that requirement here because he had a dismissal. This is the holding in the case. This is the big takeaway in the case. What this tells us is that the courts have eliminated a hurdle for plaintiffs. In most of these 1983 lawsuits, and I was part of this certainly as a city attorney, there's a criminal prosecution pending. If you get a conviction in the criminal prosecution, some of these claims, like malicious prosecution, are dismissed from the lawsuit because you have to show a favorable outcome. For example, if I'm the prosecutor and I go to court and I get a conviction for resisting evading an officer on Thompson, then malicious prosecution's dismissed. He can't proceed on that because he's got to show a favorable outcome. It's one of the elements of a malicious prosecution. The court has now eliminated that. So that bar is not there anymore. Well, I should say it's still there. It's just lower. So previously you had to make some affirmative showing, like be acquitted at trial or some factual showing. Now, if a prosecutor dismisses the case, that's it. You can move forward. It doesn't automatically mean that the case is over and done with. It's just one element of many that has to be proven. So really quick, why don't we transition back to me? Let me tell you, let's talk about a malicious prosecution claim really quick before I go through the rest of this. So a malicious prosecution claim is couched under Section 1983. There are essentially three elements that a plaintiff must prove to be successful. Element number one is that the suit or the prosecution was instituted without probable cause. So that means a plaintiff has to show that you as an officer arrested and charged criminally without probable cause. Okay, that's important to know. Number two, they have to show that the motive that you had in instituting that criminal case was malicious. And usually in most of the case law, again, that goes back to, was there probable cause to support it? And then finally, number three, what we're talking about in this case, the prosecution terminated in the acquittal or discharge of the accused. That's the three elements. Couple of misconceptions. Malicious prosecution is a legal term of art. It's a cause of action in a lawsuit. It doesn't mean we're suing the prosecutors. It means that they're suing you, the police officer, because you arrested someone, okay? They're alleging that you had no probable cause to do it, that it was motivated by, usually it comes in the context of like contempt of cop. So there has to be some motivation there. And finally, that there was a favorable outcome, which is the question being answered. In this case, there was a favorable outcome to the plaintiff in the criminal case. So that's what it is. And hopefully you understand that we're not talking about suing prosecutors here. Prosecutors, if the case has been filed, have absolute immunity. They have qualified immunity outside of that. So we're not talking about suing prosecutors. We're talking about suing you, the law enforcement officer, for arresting someone without probable cause. And they're showing that it was motivated by some malicious intent. Usually, the key thing is probable cause. So what this case does, it doesn't make some automatic thing where they can just sue you. It just makes it easier because prior to this case, it was a little bit harder for a plaintiff to show under this Heck decision that there was a favorable outcome. The court has made it easier now. If the prosecutor dismisses the case, that's it. Element 3 is met. They can move forward. Still got to prove elements 1 and 2, but you're not going to get that easy dismissal that you would get previously under Section 3. So I hope that makes a little bit of sense. Let me go through a little bit more of this case here to show you the actual opinion, because again, this first part is just a synopsis. And if you go down to page 4, when we get past that initial syllabus, kind of laying things out, we get the actual opinion of the case. So you can see opinion here, Justice Kavanaugh. And again, he just kind of starts off with framing the issue up here about what this case is about. And specifically, to maintain that Fourth Amendment claims under 1983, a plaintiff such as Thompson must demonstrate, among other things, that he obtained a favorable termination of the underlying criminal prosecution. So that's the issue of this case. That's really all this case is about. As we read it, they're just addressing that. I think a lot of officers read this case and thought, oh my God, if a DA dismisses the case, then I automatically get sued. That's not what the court's saying here. They're just focusing on element 3. They're not looking at those other things. So as we go along, there's a couple of things I want to point out in the case. Again, the court goes through the facts here, and then they start to examine sort of the why. You can see they go back to 1871, so they're going to start going through the historical context. A lot of this stuff for you as an officer, not super important to know. As an attorney, these are things you want to know because it tells you how the court sort of thinks. So you may want to know that, but in this short episode of the podcast, I want to focus on the key takeaways here. So I encourage you to read it, but let's go to what the good stuff is. And let's see, page 6 is something I definitely wanted to point out to you guys. So, okay, on page 6, you see, where is it? This page, they lay out those elements I just mentioned for malicious prosecution. Okay, here it is. 1, 2. All right, so the second to last paragraph, American courts, right here, American courts describe the elements of the malicious prosecution tort as follows, and then it lists the elements. Just like I explained to you guys, no probable cause, malicious intent, usually determined by lack of probable cause, and favorable outcome in the criminal prosecution for the defendant. Again, this case is only focused on that third element. I wanted to point this out so it's clear that you guys understand what a malicious prosecution claim is, because I think there's some confusion on what that is. All right, the next thing I want to point out, if we skip down, now the court is just going to go through the analysis here, some of the arguments made, and really the court goes back and looks at the original intent in 1871 when the malicious prosecution was born as part of 1983. And they said back in those days, the old days, you didn't have to show some favorable evidence of innocence. You just had to show that it didn't end in a conviction. The court really focused on that historical context. And then when we get to page 11, which is the next thing I want to point out to you guys, I think it was page 11. Yeah. So let's go down to page 11. This is where the court kind of gets through their analysis and they wrap it up. Key takeaway. What do you need to know about the case? Last paragraph at the bottom here. In sum, we hold the Fourth Amendment claim under 1983 for malicious prosecution does not require the plaintiff to show the criminal prosecution ended with some affirmative indication of innocence. A plaintiff need only show that the criminal prosecution ended without a conviction which Thompson satisfied. This is the big takeaway from this case. This is the change to the law. So what the court held was, when we look at that one element of malicious prosecution, which is they have to show their criminal case ended in a favorable outcome, what we mean by that is they only have to show that it did not end in a conviction. So if a prosecutor dismisses the case, nolli prosecchi, that's all they got to show. They can move on. All right. that's about all I want to show you guys on this. I don't want to make it more complicated than it needs to be, and we're getting into some of the lawyer arguments. So what do you, as a police officer, need to know about this case? Well, first of all, number one, because my mission with you is to teach you the law at a level that an attorney understands the law. I want you to understand the law at that level because law enforcement must know the law at that level if you're going to be successful as an officer today. So what do you need to know at that level? The focus needs to not necessarily be on the fact that the court made it easier for the plaintiff to proceed. In fact, that's why you need to pay attention to this more. The focus should be elements 1 and 2. In order for this lawsuit to go through, in order for an attorney to want to take that case, they're going to look at it. They have to be able to show that there was no probable cause to support the arrest, the prosecution. So that means you have to do your due diligence as an officer. You need to avoid those contempt of cop situations that we always run into when we're charging someone with resisting evading an officer. That's where the focus needs to be. Make sure you have probable cause to proceed. Make sure you have probable cause that you can rely on, and make sure it's good probable cause. Stay out of contempt of cop situations. It really goes along with these resisting, evading an officer, these lawful commands. They come up all the time in these types of lawsuits. Let me know what questions you have about it. Until next time, everybody, stay safe out there, and remember, every battle is won before it's fought. See you in the next episode.